Bonjour tout le monde. Good morning, everyone. Il faut commencer. Je suis Stephen Toop, président de la Fédération des sciences humaines, et je suis ravi de vous voir en si grand nombre aujourd'hui. I'm honored to welcome all of you this morning. Obviously, an important and very current topic. The Federation of the Humanities and Social Sciences is the national voice for Canada's scholars, students, and practitioners in the humanities and social sciences. Our membership comprises over 160 universities, colleges, scholarly associations across this great country. The Federation's Big Thinking on the Hill lecture series brings researchers from the social sciences and the humanities closer to parliamentarians and other decision makers who we hope can use what we are discussing in these Big Thinking lectures in ways that affect the lives of Canadians. This is the first edition of Big Thinking since Parliament has reconvened following the election. Congratulations to all of you newly elected or re-elected members of Parliament, and thank you all for your public service. Je veux remercier Greg Fergus, notre député parrain de la série. C'est grâce à M. Fergus que ces événements peuvent se tenir dans le magnifique restaurant du Parlement. It's wonderful to see Greg in his new role, and I want to thank him personally. I also want to thank the Social Sciences and Humanities Research Council for their continued support of our series. Si vous utilisez la traduction simultanée, pourriez-vous assurer que votre téléphone est sur le mute? I am especially pleased that we have partnered with the Pierre Elliott Trudeau Foundation, which, by granting doctoral scholarships, awarding fellowships, appointing mentors, and holding public events, encourages critical reflection and action in human rights and dignity, responsible citizenship, Canada's role in the world, and people and their natural environment. As a former president of the foundation, this partnership gives me special pleasure. I'd now like to invite Maurice Rosenberg, President and CEO of the Pierre Elliott Trudeau Foundation, well known to you as a former Deputy Minister of Foreign Affairs and former Deputy Minister of Health Canada, to introduce today's speaker. Maurice.
Merci beaucoup, Stephen, et bienvenue à tout le monde. Je suis très heureux que la Fondation Pierre Elliott Trudeau ait l'occasion de collaborer avec la Fédération des sciences humaines pour vous présenter ce discours de professeur Jocelyn Downie sur un des grands enjeux de la politique publique au Canada. As Stephen said, the Pierre Elliott Trudeau Foundation supports critical reflection and action on a range of issues important to the future of Canada and the world. And we believe that in order to accomplish this, it's essential to support leading academics to make their research and their thinking available and accessible to non-academic audiences, and that's really what the Big Thinking series is all about. So this morning, you'll hear Professor Downie discuss issues around one of the most important and most difficult health issues imaginable, how we end our lives. It's a daunting policy problem that raises a host of difficult legal, medical, and ethical questions. And we're privileged today to be joined by a true expert who can help guide us through these challenging issues. Jocelyn Downie is a Trudeau Fellow and a professor in the Faculties of Law and Medicine at Dalhousie University. She's a leading Canadian scholar on issues relating to end-of-life law and policy, and she's provided expertise and advice on the issue of assisted dying in Canada to a number of bodies, including the Canadian Senate Committee on Euthanasia and Assisted Suicide, the Royal Society of Canada Expert Panel on End-of-Life Decision-Making, the Provincial Territorial Expert Advisory Group on Physician-Assisted Dying, as well as the pro bono legal team in the case of Carter versus Canada, the decision that came out of the Supreme Court last year. So I'd ask you to please join me in welcoming Dr. Jocelyn Downie.
Well, good morning. I'm delighted to be here today to talk with you about the future of assisted death in Canada. I have to say that the organizers had a fantastic combination of great foresight and incredible luck in picking this date for this session. The Special Joint Committee of the House and the Senate on physician-assisted dying is due to release its report on Thursday, kicking off the all-important final stage of Canada's journey from a fully prohibitive to a somewhat permissive regime with respect to assisted death. The federal and provincial territorial governments and regulatory bodies for healthcare professionals will then have until June 6th to put in place a regulatory system for assisted death. So the future of assisted death will be the topic of conversation at kitchen and caucus tables across this country for the coming weeks and months. Now, before really getting going, I want to thank the Federation for the Humanities and Social Sciences for including me in the Big Thinking series, and the Pierre Elliott Trudeau Foundation for helping to sponsor this event. And in keeping with the tagline for the Big Thinking series, I'm going to try to transform, challenge, and inspire. So first, a bit of transforming. I'd suggest that we need to shift the conversation about assisted death in at least two ways. First, the conversation should no longer be about whether to permit assisted death in Canada. That ship has sailed. The Supreme Court of Canada spoke with one voice when it released its decision a year ago in the case of Carter v. Canada. The Supreme Court declared that the Criminal Code prohibitions on assisted death violate the Canadian Charter of Rights and Freedoms insofar as they block access for, and here I quote, a competent adult person who clearly consents to the termination of life and has a grievous and irremediable medical condition, including an illness, disability, or disease, that causes enduring suffering that is intolerable to the individual in the circumstances of his or her condition. So the discussion is no longer about whether to allow assisted death, but rather it's about how to do so. The shift changes the questions we ask, the values we ground our answers in, and the evidence we turn to. Second, the conversation should not be cast as assisted death or palliative care. These forms of end-of-life care are complementary, not mutually exclusive. As we've seen in a number of countries where assisted death has become legal, palliative care can be better in permissive jurisdictions than it is in restrictive ones. For example, the Netherlands and Belgium, both of which permit assisted death, score higher on the Economist's Intelligence Unit Quality of Death Index. They score higher overall and also specifically in relation to palliative care than Canada does. And palliative care can also improve following the legalization of assisted death, as has been demonstrably the case in Oregon and Belgium. It's also important to know that many palliative care physicians and nurses support assisted death. To pick but one example, supporters include the late Larry Liebrach, who is a physician widely recognized as a pioneer and a leader in palliative care in Canada. We seem to be witnessing two important phenomena. First, more palliative care providers starting to come forward in support of physician-assisted death, perhaps because they no longer feel that it's professionally unsafe to do so. And second, a generational shift from early palliative care professionals who are heavily influenced by religion to newer palliative care professionals coming to the field without a religious orientation. All of this is going to help us to stop pitting assisted death against palliative care and instead to work together across historical divides toward delivering the best end-of-life care possible. Now let's turn back to the challenging element of the Big Thinking initiative. Flash back to 2009, when the Quebec National Assembly unanimously passed a motion to create the Select Committee on Dying with Dignity. The all-party committee was chaired by Liberal Jeff Kelly, with opposition Parti Québécois Véronique Yvon as the co-chair. An act respecting end-of-life care was ultimately introduced to the National Assembly by then Minister Véronique Yvon. Ultimately, the bill was reintroduced into the National Assembly in a motion adopted unanimously by all four provincial parties. Remarkably, Véronique Yvon was included as a co-author of the bill, along with Gaétan Barrette, the current Minister of Health and Social Services, even though her political party was no longer in power. So with that story in mind, here's the first challenge. It's for the parliamentarians in the room, and it's to maintain the tone set by the Quebec Select Committee. If ever there was an issue over which to work collaboratively across party lines, it's how we die. My second challenge is related to the first one, in that it also relates to collaboration. The regulation of assisted death rests at two levels of government, federal and provincial territorial. Some things rest solely, clearly, with the federal government. For example, who can have access to assisted death? Others rest solely with the provincial territorial governments. For example, what should be recorded on medical certificates of death for people who have accessed assisted death, and whether physicians have a duty to refer or to transfer care when they conscientiously object to participating in assisted death. Still others could arguably go to either or both levels. For example, requirements about consent, capacity assessments, documentation, reporting, and oversight. If ever there was a moment for cooperative federalism, this is it. Significant confusion and court challenges can be avoided if the two levels of government work together. Significant efficiencies and effectiveness, as well as consistency and comprehensiveness gains, can be realized if the two levels of government work together. So the second challenge is for each of us to take every opportunity to press the federal, provincial, and territorial ministers of justice and health to work together to ensure the least constitutional wrangling and the greatest harmonization possible. There are mechanisms and precedents for doing so. For example, administrative interdelegation, substantial equivalence clauses, uniform law conference. We must use them. Unfortunately, so far, we have seen positive words from both levels of government, but no meaningful action in this regard. So pressure is clearly needed. Now, in the coming days or weeks, the government will decide on legislative drafting instructions, and soon we will see a bill. And so here's the third challenge. It's for everyone in the room to be ready and to engage. Engage in the conversation about how we regulate assisted death. So allow me to outline some topics about which you will need to be ready to engage. These are, I believe, the issues about which there will be the greatest need for reflection, deliberation, decision-making, and consensus building. Who can have access? Should access to assisted death be limited to those who are terminally ill, to those who have passed the age of majority? Should access to assisted death be prohibited or more restrictively regulated for individuals with mental illness, with traumatic injury, with disabilities? Should access to assisted death be limited to those who are competent at the precise moment of the administration of the assistance? Or should competence at the time of making the request suffice? How can we ensure access? Should the provision of assisted death be limited to physicians? Or should a nurse under the direction of a physician or a nurse practitioner acting autonomously be permitted to provide assistance? Should healthcare providers and/or institutions be permitted to refuse to participate in assisted death on the grounds of conscience or professional philosophical objection? Case review. Should there be review of all cases of assisted death? If so, prior to the death as a form of pre-approval, or after the death as a form of compliance assessment? System oversight. Should there be a system oversight entity? If so, at what level, federal, provincial, territorial, or national? And with what mandate? Division of powers. Who should do what legislatively? Should there be minimal federal intervention, leaving most of the regulation to the provincial territorial governments? Or minimal federal and provincial territorial legislation, leaving most of the regulation to the health professional regulatory bodies? I obviously don't have time to go into all of these issues, but I wanted to get them all on the table for our discussion period and all on your radar for the coming months. I'm going to explore just a sample of these, but I obviously welcome discussion of any of these in the Q&A. So first, minors. Should a competent 18-year, 11-month-old with end-stage bone cancer be able to access assisted death? Or must she wait 1 month in excruciating pain to reach her 19th birthday? The Supreme Court of Canada talked of competent adults, and so it might seem access should be limited to those who have passed the age of majority. But there are a number of arguments that cut against that conclusion. First, the Supreme Court didn't define adult. And of course, the Supreme Court knew that adult has been defined in various statutes and the common law as a variety of ages beyond 18 and 19, down to 16, down to 14. It's also important to note that across Canada, it's well established in law that mature minors have the authority to make healthcare decisions, even where the consequences will be death. It's also important to note that the Supreme Court, in a case called AC, held that an irrebuttable presumption of incapacity based on age violates the Charter. That said, the issue of mature minors was not before the Supreme Court on the facts of Carter, and the Court did use the word adult. So where does that leave us? Basically, it would not be inconsistent with Carter to exclude mature minors, but it would, I think, violate the Charter and be inconsistent with established health law policy and practice to do so. It would be better, I would argue, to allow access for mature minors, restricting access under the legislation on the basis of capacity, not chronological age. Now, mental illness. Should assisted death be accessible by individuals who have mental illness? If so, should individuals with mental illness seeking access face different and higher hurdles than those without mental illness? I'd argue that mental illness per se should not be an exclusion criteria, nor should it trigger different and higher hurdles. But that is not to say that it shouldn't receive intense scrutiny. Mental illness was not included by the Supreme Court. Not all individuals with mental illness are incompetent, and physicians already routinely determine capacity, excuse me, whether someone is competent for life and death decision making, even where they have a mental illness. Furthermore, the suffering that can accompany mental illness can be as excruciating as the suffering that can accompany physical illness. Finally, I'd argue that excluding individuals on the basis of mental illness would violate the equality provisions of the Charter. Others, of course, will offer differing views. Some, for example, will say that mental illness is always remediable, so doesn't meet the criteria in Carter. But this neglects the fact that the Supreme Court defined irremediable as cannot be alleviated by a means acceptable to the patient. There can certainly be cases of mental illness that cannot be alleviated by a means acceptable to the patient. Some will say that mental illness muddies capacity assessments, thereby justifying different and higher hurdles. Now, it's true that mental illnesses, some make capacity assessments difficult, and some mental illnesses render a patient incapable of autonomous decision-making. However, some physical illnesses make capacity assessments difficult, and some physical illnesses render the patient incapable of autonomous decision-making. The response to physical illnesses is to insist upon careful capacity assessments in all cases, involving specialists where the assessment lies outside the professional competency of the physicians otherwise involved. The same should be required for mental illnesses. There's no justification for treating people with mental illnesses differently. Where capacity is uncertain, heightened scrutiny should be required for both. Where capacity is not uncertain, heightened scrutiny should not be required for either. To do otherwise risks making mental illness a proxy for incapacity, and that's quite simply empirically false and discriminatory. Now let's turn to, this is not working well. There we go. Requests made in advance of loss of capacity. Should access to assisted death be limited to those who are competent at the precise moment of the administration of the assistance? In Carter, the Supreme Court of Canada referred to competent individuals, but didn't say whether the individual needed to be competent at the time of the provision of the assistance or at the time of making the request. On this issue, I would agree with the Provincial Territorial Expert Advisory Group on Physician-Assisted Dying and over 80% of Canadians that the best position for Canada to take at this time is to require the following. At the time of the request, the patient must have a grievous and irremediable condition and be competent. At the time of the provision of assistance, the patient must have a grievous and irremediable condition and be experiencing intolerable suffering by the standards set by the patient at the time or prior to losing capacity. This approach prevents the tragic case of someone having met all of the criteria but being denied assisted death because they become incompetent before it can be provided. This approach also prevents someone from killing themselves earlier than they otherwise would for fear of becoming incompetent before reaching the point of intolerable suffering. For example, a person with progressive dementia. And finally, oversight. Should there be an oversight body? If so, with what mandate? To quote the Provincial Territorial Expert Advisory Group on Physician-Assisted Dying, It is essential for a properly functioning regulatory framework that there is robust and independent oversight to monitor compliance with relevant laws, policies, and standards, to inform continuing development of policies and practices, and to ensure public confidence in the integrity of the system. To these ends, I would argue that we need an oversight commission to perform the following functions: to develop and manage a system of regional review committees to retrospectively review all cases of medically assisted death to determine compliance with the federal legislation; to make available to the public an annual report on information submitted to the Commission by the regional review committees and healthcare professionals participating in assisted death; to support the development and delivery of education on ethical, legal, and clinical aspects of medically assisted death to healthcare providers, legal professionals, and the public; to support the development and maintenance of a network of healthcare providers to ensure support, consultation, and education for healthcare providers who are providing medically assisted death, and access to medically assisted death for patients; to conduct or commission research it deems necessary for ongoing evidence-based policymaking about end-of-life care in Canada; and to make recommendations to the relevant authorities for law and policy reform with respect to end-of-life care in Canada. Ideally, the federal parliament could set up a national commission, and the provinces and territories could use the mechanism of administrative interdelegation to ensure its uncontested legitimacy. That is, they could delegate their own oversight powers to this body. Quebec could retain its already established system, and one hopes cooperate on data gathering, analysis, and reporting. Absent cooperation, Parliament could set up a federal commission. So that's a brief overview of some issues that must be addressed in the coming weeks and months. Now, like the flight attendants who have to remind us all of the exit doors, the location of the exit doors, and flights over 4 hours, let me remind you of what my third challenge was. That is for everyone in the room to be ready and engage in the conversation about these issues. Now, my fourth and final challenge relates to how you get ready and engage in these conversations, specifically how you approach evidence. You will read and hear many claims about the supposed horrors going on in other permissive jurisdictions. Many of these claims were already tested in court in Carter under cross-examination and found to be unpersuasive. The Crown even took the highly unusual step of introducing new evidence about Belgium at the Supreme Court of Canada, claiming that it had come to light after the trial. Yet again, it was found unpersuasive. In addition, many of the claims that you hear will be false or misleading. Many of them will be anecdotal and sourced only to newspapers and blogs. It's very important to remember two questions central to the reliability of evidence. How high up on the pyramid of quality is the source of the evidence, and has the evidence been tested? The pyramid has at the bottom, as the weakest form of evidence, anecdotes, opinions, editorials, and letters to the editor. Next up, reports on single cases, then small groups. Next up, epidemiologic studies, and at the top, meta-analyses and systematic reviews. Testing of evidence happens through peer review, but also through nonpartisan parliamentary committees, as in Quebec, expert panels, as in the Royal Society of Canada and the Provincial Territorial Expert Advisory Group, and courts, as in Carter. Not surprisingly, a wave of stories about assisted death in the Netherlands and Belgium in particular has recently begun. But we should be very wary of basing law and policy on untested anecdotes and media accounts. A strong antidote for these is to go back and read or reread Justice Smith's exemplary decision in Carter v. Canada. As well, turn to the very people the Federation of Social Sciences and Humanities represents, Canadian researchers. Empirical researchers can properly evaluate the claims. Note that I am not referring you to consumers of research, like law professors like me or journalists, but rather the producers of research. They have the expertise to evaluate the reliability. Finally, let's end with some inspiring. Canada is rapidly moving into a new reality for end-of-life care. This presents us with two extraordinary opportunities. In the short term, we have the opportunity to develop and implement, quite simply, the best regulatory framework for assisted dying in the world. We can do this for a number of reasons. There is incredibly strong public support for decriminalization, 75 to 80% for many years now. We have a very strong Supreme Court of Canada decision on this issue. It was signed by the court to put an exclamation point on the unanimity of the court. And it was built upon an incredibly rigorous trial decision, which provided the factual foundation for the decision and, I would argue, the legislation to follow. There is a very clear values base behind the public support and the judicial decisions, so we can use those values as guide stars in the development of the regulatory framework. And there's a wealth of information available from the other jurisdictions that have gone before us. We can study their experiences, and we have, learn from them, emulate their strengths, and avoid their pitfalls. My hope is for us to be able to say the following in 4 months' time. We now have a system for assisted death that was crafted across party lines. Its core elements are harmonized across jurisdictional lines. It is grounded in valid and reliable evidence. It recognizes the primacy of wishes of capable individuals expressed freely and clearly with respect to assisted death, provides for access to assisted death, reconciles freedom of conscience of healthcare providers and the right to life, liberty, and security of the person for all residents of Canada. And it ensures that the vulnerable are well protected and the system of assisted death in Canada is well monitored. In the longer term, we have the opportunity to develop and implement, quite simply, the best system in the world for end-of-life care. We've been focusing on assisted death for a long while now, it's longer for some than others. But once the project of designing and implementing the regulatory framework for assisted death is done, we should resist the temptation to turn our attention to the newest shiny thing. Rather, we should keep our focus on end-of-life care, for there will still be much to improve. Palliative care, how do we increase quality and access? Advanced directives, how do we increase the use and the quality of documents used to set out what healthcare decisions we want made in the future when we are incompetent? Capacity assessments, how do we better evaluate vulnerability and support decision-making for individuals? Palliative sedation, should at least some deep and continuous sedation, when it's paired with the withholding and withdrawal of artificial hydration and nutrition, be regulated as we regulate euthanasia? And unilateral withholding and withdrawal of potentially life-sustaining treatment. Should physicians have the authority to withhold or withdraw potentially life-sustaining treatment without the knowledge or against the wishes of the patient and her family? These are all critically important issues that will remain to be answered even after we usher in assisted death in June. And my hope is that we can take the skills we've honed, developing the regulatory framework for assisted death, and apply them to end-of-life care more broadly. That we can continue to work across party lines and jurisdictional divides, and base law and policy on sound evidence and clearly articulated core values. That we can have a legal and health system in Canada that is the envy of the world, and more importantly, allows us to truly care for the dying. With that, I turn the floor over to you.
Well, thank you, Professor Downie, for what was, to me, a marvelously lucid, compelling, and cogent presentation. So we now have the opportunity to pose questions. I'm sure there are a few that remain. Please use the microphone, which is in the center of the room. Vous pouvez poser vos questions ou en anglais ou en français, évidemment. But please, whichever language you use, identify yourself first, and please try to keep questions brief so that we can get through many. Merci beaucoup.
Thank you for a great presentation. You're fantastic, and I love you. But I'm Heather Sams, and I'm from Shirk. I had a debate about this recently with some friends. Maybe you can answer the question, maybe not. But what happens in the case of insurance when someone does actually decide to take their life?
Right. Oh, I'm so glad you asked that, because I thought it was going to be a problem. But it's actually not. In that the Canadian Health and Life Insurance Association has said that as long as people follow the regulatory framework, there will be no exclusions for assisted death. So that's the first thing to know. They're not going to treat it as suicide where you often have the exclusion clause, although I would note we all think you can't get coverage if you have suicide. It's actually not true. But they have said not a problem for assisted death if you follow the clear regulatory framework. The second thing is we do need a tweak in provincial legislation, probably, to allow it, because under the common law, you can't cause a harm and get remediated for it. But we have an exclusion in statute to override that for suicide, so we need to do the exact same thing. We just need to put the words in to provincial legislation. What this highlights is the fact that there's so many moving parts to this. So while the federal government has to make things possible, the provincial territorial governments have to look at a bunch of different pieces of legislation. So it's actually not to deal with the insurance companies, but rather it's to deal with a common law exclusion. But that will not be a problem, is the bottom line, I think.
I'm Sheila Malcolmson. I'm a member of Parliament, and I'm worried that the court did not give the government time to do public consultation on this. So in my 12 years of elected life, I've seen the greatest ideas with the strongest foundation get huge kickback when the public doesn't feel that they get a chance to chew on it. Mm-hmm. So I wonder if you share that concern and how we might mitigate it as members of Parliament. Thanks.
So the first thing, I suppose, in defense of the court is the court gave 12 months. They weren't used. So I don't think we lay the blame on the rapidity with which we need to deal with this issue on the court. The second is to say, while Parliament and parliamentarians may not have been spending a lot of time on this issue for a long time, so it feels really short, a lot of other people have, including the Canadian public. They've been thinking about this and talking about this and learning about this for a very long time. And so I think that you can rely on a lot of the consultation that's been done leading up to this. So even though it's not Parliament's public consultation, there's a lot of public consultation and engagement that's happened. And I think you can reasonably rely on that. And so it's a much stronger foundation than it might look if you just thought, well, what's the federal government done in relation to a public consultation? That would look small. But if you look at the public consultations on what the law should be on this across the country, it's very, very rich.
Hi, I'm Ken Hardy. I'm also a member of Parliament. This isn't just a transaction between somebody with end-of-life issues and a regulatory system and the medical system. There's families, there's communities, there's churches, and they will all demand a role. So the question is, what has to happen outside of the framework that you've been talking about to basically get that kind of support, again, on behalf of the person? Because we can agree in very broad brush general terms that certain things should apply, but the condition always changes when it comes down to one person.
So what do we do to bring family on board?
Yeah, well, I mean, what kind of support?
Yeah,
I mean, even in palliative
response.
care, there's a necessity to have basically a working relationship with the family,
Yeah.
and sometimes with the community.
Yeah, so what I'd say is we actually need to see assisted death as being a part of the spectrum of end-of-life care and recognize that so much of what is raised as a concern around assisted death happens in the context of withholding and withdrawal of treatment, palliative care, all these things that we already do. So we need to not make it extraordinary. We need to normalize it and recognize it fits within the spectrum of medical care. And this is something that Justice Smith said in Carter. And so I think we recognize, we talk in terms of family-centered, patient-centered care where you recognize that the patient is a part of a social context. But we also recognize when we're in palliative care or other end-of-life decision-making, not assisted death, that some people have no family or some people are estranged from their family. And you don't force family engagement on a patient who doesn't want it in the context of a refusal of treatment, for instance. So similarly, I would say, you don't force it on someone in the context of assisted death. But we recognize the importance, and this will happen in the context of team-based medicine, which is another thing we haven't paid enough attention to, and the fact that people exist in community. And we attend to that, and healthcare professionals are well set up and oriented to attend to the social context of patients. And I don't think that would be any different in the context of assisted death.
The issue could be, I suppose, in part, the resistance that you would get from family and from the community. But the other part is that the family and the community also need support.
Yes.
So how is that accommodated in the framework, or is it? Or
It's
does
accommodated in the framework of the delivery of healthcare. There's not everything has to happen at the level of the federal parliament and the regulatory framework in relation to the criminal code. That's one of the things about this is it's criminal law and it's health. So there are aspects that are going to get dealt with through different mechanisms. So the criteria for access is clearly inside the criminal code. The kinds of things you're raising are within the delivery of healthcare. And so that is going to be coming about as a result of not even provincial territorial legislation, but rather at the level of healthcare institutions and healthcare professional associations, developing these systems to ensure that assisted death wraps in with all the other protections and the support for families and communities that comes along with all kinds of difficult healthcare decisions that we have to make. So it fits into the healthcare context. It's not to say those aren't important issues, but to say that's where they rest, and we are well situated to do that kind of support because healthcare professionals already do that all the time around very difficult healthcare decisions.
My name is Rule Amder. I write for Canadian Charger. By profession, I'm a social worker. When I read the Supreme Court decision, the thing that comes through to me is that the decision of the patient is according to that person's decision, that person's feeling that he's had enough suffering. Mm-hmm. And to my mind, that leaves the definition of when the person is entitled to end of life assistance in ending it is like Kevorkian. If you want it, you get it. I don't see any limitation there.
Oh.
And the possible limitation would be compos mentis. But I don't see the psychiatrists jumping into helping make the decisions in that line either.
Right. So it is constrained, and it is constrained by the fact that you have to have a grievous and irremediable condition, and that is not so much a subjective assessment. So you must have that in order to have access. And then the suffering is subjectively assessed. You must have enduring and intolerable suffering, and you must have capacity. You must have capacity for decision making. So this is not a free-for-all. This is not a just open the barn door and let everything go. It is constrained by those criteria.
Well, the point being that the grievous the grievous condition is grievous as the person defines it.
Well, that's going to be interesting to see what comes out. Let's watch for the report on Thursday and see what the federal government does, because it's an open question as to whether they will say that as an entirely objective assessment or whether it is a both objective and subjective. So you bring the physician in. The physician has to actually agree that it's a grievous and irremediable condition, or whether it is purely up to the patient. And there will be an element of reasonableness built into that standard too, I would suggest. So the suffering piece is truly purely subjective, but the other I don't believe will be. And so it's not just going to be, I get to say, I have a hangnail, that's a grievous and irremediable condition. It's just not what's going to be in the legislation. It's not what's going to be in policy, and it's not what's going to be in practice. And the other thing to remember is I have good reason to say that because we have decades of experience in other jurisdictions now that show that that is not what people come forward with. We know the conditions, and they are grievous and irremediable.
Okay.
Hi, my name is Selena Caesar Chavan. I'm the member from Whitby. I wanted to thank you for your talk today. I wonder if you could provide some further insight around capacity and consent. Mm-hmm. You spoke about ensuring a process at time of diagnosis. Mm-hmm. And I'm reminded when you say that about the excruciating decision around, sexual reassignment, for example, where the assessments occur in advance or along a continuum over time. And I'm wondering if you think that the assessment is better done at the time of terminal or a terminal diagnosis instead, so that we have a better assessment of vulnerability over time as opposed to right at that moment.
Sure. I misspoke if I suggested that the capacity assessment happens at the time of the diagnosis. It's after. The point is the request can only come after the receipt of the diagnosis. And then you would go into a process, as you describe, of assessing capacity, and it will be over greater and shorter lengths of time depending on the condition of the patient. So the position taken was to say we're not advocating for requests to be able to be made, binding requests to be able to be made before you even have a diagnosis of a problem. So I can't now say if I get dementia, if I have Alzheimer's and I'm stage 7 Alzheimer's, I want assisted death because I don't yet have it. Or I can't write a broad advance directive that says, if I am no longer able to recognize my family for whatever reason I want it, the line is that you have to have had that diagnosis. And the justification for that is a sense that it needs to be a fully informed decision. And the way to ensure that it is informed is that you actually know your condition. So your declaration can be very specific. You understand the trajectory of the disease. You have an opportunity to come to grips with what you've got and figure out what it's going to mean. So it's that it can't happen until after, but it's not done at.
I think I misspoke. I meant you said at time of request.
Yes.
Yeah. So I'm wondering if it should be at time of diagnosis versus at time of request.
Oh, you want to move the capacity?
So once you get the diagnosis, then we start the assessment.
Yep.
So that when the request is made, you have that understanding of the patient's or of the person's psychological being as well as the deterioration of the physical being. And therefore, at time of request, you're better able to assess capacity and consent.
Yeah, so you would be assessing capacity all the way through. Probably we're going to have some sense that you have to have, probably we're going to have 2 physicians who have to be involved or 2 healthcare providers because it may not be limited to physicians. So that in itself introduces a time lag. We may see a time requirement, especially in certain circumstances, for certain conditions. So there is going to be this period over which you're coming to know the patient and you're doing capacity assessment. And we do this in healthcare all the time, right? Around decision making, even in the circumstance that you were talking about. It's a process of coming to be confident that the individual is making a free, informed decision and they have the capacity to do so. Sometimes you can do that. You can do that in a day. People who saw the video of Dr. Donald Lowe, his capacity assessment was not complicated, right? A lot of people, but another circumstance, it could be very complicated. And the key thing to remember is that the healthcare providers have to be confident that the individual meets all the criteria, capacity being one of those criteria. And they take the amount of time it takes for them to make that. So somebody who's refusing treatment, for instance, I want to stop dialysis, it may take weeks of back and forth between me and the physician for that physician to be certain that I am making a free and informed decision to stop treatment, because I am going to die if I stop dialysis, say. Other circumstances, it may take a day for them to be confident. But the key is the confidence in the healthcare provider. And whether it's that they get it from their own professional competency, because it's a perfectly clear case of capacity assessment. If it's complicated, I turn to a second opinion. I bring in additional professional competency. Am I getting at what you're... Okay.
Thank you. Ray Pennings. I'm the co-founder of Cardis, the think tank. We've been doing a fair bit of work on palliative care, and I appreciate very much your highlighting the fact that not only do we need to focus on the regulatory framework for assisted dying, but also in terms of the provision of palliative care. I guess I look at the fact that for 2 decades that refrain has been happening on palliative care, and we're still at a state, depending on whose numbers you believe, only 40% of Canadians have access to the best palliative care that is there. So I'm a little less optimistic about given the fact that 2 decades of work that has been supported by all parties has not really seen the success that most Canadians would probably think that we need. I guess in that light, I wonder why the insistence on the framework, recognizing the contentiousness of assisted suicide. And I agree the fact that the court has maybe been very clear on that, and there are perhaps, depending on the poll you believe, I think all sides have to agree it is a morally contentious issue with a significant segment of the Canadian society. So I wonder, in light of that, why would we insist on this being part of the continuum of healthcare as opposed to taking it out of the healthcare system and having it as a separate regulatory regime? I think there are at least three compelling arguments for that. One, the doctor that I care for, that cares for me in terms of my health, is not the same doctor that I'm looking for in terms of assisted dying, and there is no confusion of roles, which I know from other jurisdictions leads, whether real or perceived, leads to a lack of confidence in the healthcare system on the part of some. Secondly, in terms of the training, we haven't managed to train all of our doctors in palliative care. Why would we pour resources into training the entire medical system for something that has a relatively small incidence rate when we could concentrate the training on a far more focused group to deliver that? And thirdly, the broader social effect of those who have very strong conscience rights or conscience convictions about this will start leaving the medical system and not considering that as an area for their active participation because of their not wanting to participate in this regime. So it strikes me that we could, whatever your opinion, and leaving aside the moral contentiousness of this, we could put a framework in place that would be far more inclusive if we took it out of the continuum of healthcare.
Okay. So there's loads in there. I can only respond to a few things. The issue of moving it out of healthcare, just to pick up on a few of the things you say. The first is the doctor's not the same, the confusion of roles, the lack of trust. The evidence does not support that. The level of trust in physicians in the Netherlands, for instance, is very, very strong. So that's an example where we need to go and look at the primary sources and look at the evidence. It does not confuse the roles. It does not undermine trust. It enhances trust because patients believe that their healthcare providers will give them what they need. It's one of the things that not everybody accesses assisted death who can have it. It's the comfort that comes from knowing that the door's not locked. It means you don't necessarily go through the door, but the stress level goes down, the quality of the dying goes down, and you never access assisted death. Second thing, training people. We don't, in fact, need to train the entire medical system to do this. It's also not so complicated. Much of this is why you embed it in the healthcare system, is much of what needs to be done, the capacity assessments, the assessment of all the criteria, is what healthcare providers are trained to do. So if you set something else up outside, you'd be training people to do all of these things that healthcare providers already do and are already trained to do. Plus, the reason to do this is we have a right to it. This is something that the court has said. Finally, on conscience, I mean, the piece of saying that, physicians who object, healthcare providers who object will leave the system, that is deeply problematic kind of a statement because you cannot have healthcare providers who object to something that Canadians have a right to hold hostage the system by saying we're going to leave. That's just not how conscience should work. Conscience has to be reconciled, which is what the Supreme Court of Canada said, reconciled. That doesn't mean it's a veto. It doesn't mean it's a trump. So it means it needs to be respected. We have to find mechanisms through which healthcare providers who object can not have to participate, but do have to have an obligation to ensure access. We have a tragic history in Canada with respect to conscience and physicians and lack of access to a medically necessary service, which is abortion. So we need to be very, very careful about that kind of a move. Final question.
Bonjour, professeur. Mon nom est Nicolas Diorio. Je suis le député de Saint-Léonard-Saint-Michel. Et je voudrais tout d'abord vous féliciter pour la qualité et la concision de la grille d'analyse que vous nous avez présentée. Mourir dans la dignité, dying with dignity. The important word is dignity. And obviously, we're going to be crafting a piece of legislation. We are governed by the rule of law. We have due process. What I ask you is, could you enlighten us? And you referred to experiences in Scandinavia. but they don't have the same level of contentiousness when we regard the application of a statute. And we've heard limited resources. We've heard families might want to intervene. You referred to the fact that the process could be a prolonged one. My concern is this. I would not want this to become a highly specialized field of law practice, because that would import impact on the dignity. I mean, we are talking with a person, a human being, that obviously has to receive special attention and not be dragged into legal proceedings. So my concern is real. It's how could we mitigate this, having in mind that we live in a society based on rule of law. We're going to have a statute that will be complemented by regulations. And, as you mentioned, we live in a multi-jurisdiction state. So if you could just please enlighten us how this will translate into reality.
Okay.
Thank you.
So, yeah, it's not a make-work project for lawyers. Don't tell my students. But no, because lawyers are going to be engaged in the next 4 months because you can get a constitutional exemption. And for people to have access now, between now and June 6th, they do actually have to go to court to get an authorization for access to assisted death outside of Quebec. So there will be a bit there, but we're working to have that be a pro bono network of lawyers who will work for free for people who want this. So it's not going to be a lot of people. The way to prevent this from becoming something that a lot of lawyers spend a lot of time on is for the federal government and the provinces and the territories to cooperate at the outset. What I fear most is that the federal government goes forward and then there's all kinds of jurisdictional challenges to the legislation because they're seen to have trenched into provincial jurisdiction. That will keep a whole lot of lawyers busy. And I think we can avoid that by doing something maybe a bit fresh, which is to cooperate, to communicate early and often about how the system is going to work, because it is federal, provincial, and it is justice and health. So we need to do a whole lot of talking to keep the lawyers, I say this as one, out of it, because then it is inside the healthcare system, and you don't need lawyers. I mean, you need a lawyer less for this than you do for an advance directive. It needs to be built into the healthcare system, and you are consenting to it in the way that you would consent to palliative sedation, for instance. You don't need a lawyer for the consent to palliative sedation. So I don't think it will become something that is a domain of specialization for lawyers in practice. Where we will see ongoing work, I hope, is actually the law reform around all of end-of-life care. And that's where we can usefully play a part, not in fighting these things or having to get legal advice every time you want to have something like this. It should be laid out in the regulatory framework, clarity and precision.
Merci beaucoup, tout le monde. Your questions were very thoughtful and I must say aided in further clarifying some very complex issues. I apparently have a secret compartment here. And in it, there is a small token of our appreciation for Professor Downie for taking the time to be with us today. I must say that in trying to utilize the framework of big thinking, she truly did offer some transformative ideas, some significant challenges reaffirmed right at the end, and I think some true inspiration. So I want to say on behalf of the Federation for the Humanities and Social Sciences, and frankly for all of us who toil across the country in these complex areas, thank you for a wonderful presentation. Thank you very much.